Imagine this. A client walks into your office worried. He says, I was arrested yesterday. What will happen next? As lawyers, we often need to explain the steps of the criminal justice process in clear, simple English. From arrest to appeal, clients want to know, will I stay in jail or can I post bail? When will I go to trial? What happens if I am convicted? Can I appeal? In this lesson, we will learn how to explain the sequence of a criminal case using clear legal English. We will focus on vocabulary like arrest, trial, verdict, and parole. We'll also practice using sequencing grammar to guide clients through each stage step by step. By the end, you'll be able to explain the criminal justice process confidently and professionally. By the end of today's lesson, you will use intermediate level vocabulary like arrest, charge, bail, trial, verdict, sentencing, appeal, and parole. You will explain the steps of the criminal process with sequencing words like first, then, after that, and finally. You will apply legal phrases such as post bail, stand trial, enter a plea, file an appeal, and use key expressions like the right to remain silent, presumption of innocence, legal representation, and custodial sentence. This will help you explain complex procedures in simple, professional English that your clients can understand. Let's begin with a story. A businessman in Spain is accused of fraud. He calls his lawyer and asks, what happens now? The lawyer explains step by step. First, you are arrested and informed of the charges. Then, the court will decide if you can post bail or if you must remain in custody until trial. After that, you will stand trial. The prosecution and defense will present their arguments and the jury will decide. Finally, if you are convicted, you can file an appeal to a higher court. If you are acquitted, you will be free immediately. By using sequencing words first, then, after that, finally, the lawyer makes the process clear and less frightening for the client. This shows how legal English can turn complex procedures into simple, understandable advice. An arrest happens when the police take a person into custody. It does not mean they are guilty, it only means there's reason to suspect them. For example, the suspect was arrested after the investigation. Imagine a person is stopped by police outside a bank. They are told, you are under arrest for attempted robbery. The lawyer explains to the client, at the moment of arrest, you still have rights. You must be informed of the reason for the arrest, and you have the right to remain silent. The arrest is the first step in most criminal cases. A charge is the official statement that a person is accused of a specific crime. It usually comes after the arrest. For example, the defendant was charged with theft. Imagine, after the arrest, the prosecutor reviews the evidence and says, we are filing charges of fraud and forgery. The lawyer tells the client, you have now been charged. This means the case will move forward to court. The charge is what turns suspicion into a formal legal process. Bail is money or conditions set by the court to guarantee that the accused will return for trial. If bail is paid or conditions are met, the person does not stay in jail before trial. For example, the suspect was released on bail. Imagine a student is arrested for assault. The judge says you can be released if you post $5,000 bail. The lawyer explains bail is like a promise. If you do not appear at trial, the money is lost, and you may be arrested again. Bail is important because it protects the accused's freedom while ensuring they appear in court. A trial is the central event in a criminal case. It is where the prosecution and defense present evidence. Witnesses are questioned, and a judge or jury, depending on the country, decides the outcome. For example, the trial began with opening statements. Imagine a defendant accused of theft sits in court. The prosecutor tells the jury, "We will prove beyond reasonable doubt that the defendant committed this crime." The defense lawyer replies, "We will show the evidence is not strong enough." The trial is the stage where arguments are tested and justice is decided. A jury is a group of ordinary citizens chosen to decide the facts of a case. They listen to the evidence, deliberate, and return a verdict. For example, the jury found the defendant guilty. Imagine a fraud case in the United States. 12 jurors sit in a courtroom, listening carefully to witnesses. After days of discussion, they return with a verdict. The lawyer explains. The jury decides guilt or innocence. The judge controls the law and the sentence. Not all countries use juries, but where they exist, they play a central role in criminal trials. The verdict is the formal decision at the end of the trial. It answers the question, did the accused commit the crime? For example, the verdict was not guilty. Let's look at a story. After a long trial, the jury returns. The judge asks, "Have you reached a verdict?" The jury foreperson replies, "Yes, we find the defendant not guilty." The verdict is the moment of truth in every trial. It decides the future of the accused. 3 important words describe what happens after the verdict. Sentencing. If convicted, the court decides the punishment. For example, the defendant was sentenced to 5 years in prison. Appeal. If the defense disagrees with the verdict, they can ask a higher court to review. For example, the lawyer filed an appeal against the conviction. And parole, which is early release from prison, usually for good behavior and under certain conditions. For example, the prisoner was released on parole after serving half of the sentence. And let's look at a story. A man is convicted of assault. He was sentenced to 3 years in prison. His lawyer immediately filed an appeal, arguing the trial was unfair. After serving half his time, he was released on parole with strict conditions. These 3 terms show how the criminal justice process can continue even after the trial ends. In criminal law, lawyers often explain the sequence of events to clients, sequencing words like first, then, after that, finally, make the process easier to follow. For example, first, the suspect was arrested. Then, he was charged. After that, the trial began. Finally, the jury gave a verdict. Notice how each word tells us exactly where we are in the process. Let's look at a story. A lawyer explains to a worried client. First, you were arrested last night. Then, you were formally charged this morning. After that, the court will decide on bail tomorrow. Finally, if the case goes to trial, the judge or jury will decide the verdict. This structure is very useful because it makes a complicated process simple and clear. We use sequencing words not only for the past, but also to explain future steps in the criminal process. This helps clients know what to expect. For example, first, bail will be decided. Then, the trial will start. After that, the jury will give a verdict. Finally, the judge will sentence you if convicted. Let's look at a story. A lawyer meets a client who has just been arrested. The client asks, "What happens next?" The lawyer answers step by step. First, the court will decide if you can post bail. Then, the prosecution will prepare the case. After that, we will go to trial and present your defense. And finally, the jury or judge will give a verdict. And if guilty, a sentence will follow. By using sequencing words, lawyers can explain the criminal justice process clearly, even to clients who know little about law. To post bail means to give money or meet conditions set by the court so that an accused person can leave jail before trial. For example, the defendant posted bail and was released. Let's look at a story. A college student is arrested for theft. The judge sets bail at $3,000. The family pays the money and the student is released. The lawyer explains, by posting bail, you promise to return for trial. If you don't appear, the money is lost and you can be arrested again. Posting bail protects the presumption of innocence by letting people stay free while waiting for trial. To stand trial means to appear in court, where the prosecution presents evidence and the judge or jury decides guilt or innocence. For example, the suspect stood trial for fraud. Let's take a look at a story. A business executive is accused of fraud. After being charged, he must stand trial in the criminal court. The lawyer explains to his family, standing trial doesn't mean he is guilty. It means the evidence will be examined and the court will decide. This phrase shows the formality and seriousness of the criminal process. To enter a plea means to formally answer the charges by saying guilty or not guilty. This usually happens at the first court appearance. For example, the defendant entered a plea of not guilty. Let's look at a story. A judge asks, "How do you plead to the charge of assault?" The defendant replies, "I enter a plea of not guilty." The lawyer explains, by entering this plea, the case continues to trial. If he had pleaded guilty, sentencing would happen immediately. This phrase is key because it sets the direction of the case, trial or sentencing. To file an appeal means to formally request a higher court to review the verdict or sentence. For example, the lawyer filed an appeal against the conviction. Let's take a look at another story. A man is convicted of assault and sentenced to 3 years in prison. His lawyer believes the trial was unfair. She tells the client, "We will file an appeal." This means a higher court will review the evidence and the procedure. They can confirm, reduce, or even cancel the conviction. Filing an appeal gives clients hope and shows that criminal cases may continue beyond the first trial. In the criminal justice process, these key expressions are essential when advising clients. Right to remain silent. This protects the accused from self-incrimination. For example, the police informed him of his right to remain silent. Legal representation. Every accused person has the right to a lawyer. For example, she asked for legal representation before answering questions. Custodial sentence is a sentence that requires prison time. For example, the judge imposed a custodial sentence of 2 years. Probation, an alternative to prison where the person must follow conditions under supervision. For example, the defendant was given probation instead of jail. And double jeopardy, the legal rule that prevents someone from being tried again for the same offense once acquitted. For example, the appeal was rejected because it would violate double jeopardy, and presumption of innocence, the principle that the accused is innocent until proven guilty. For example, the judge reminded the jury about the presumption of innocence. These expressions give you the vocabulary to explain not just the steps, but also the rights and principles behind the criminal justice process. Let's put it all together with the full story. A young professional is accused of fraud. She sits down with her lawyer, nervous, and asks, "What will happen to me?" The lawyer explains step by step, using sequencing words to make it clear. First, you are arrested and formally charged with fraud. Then, the judge will decide on bail. If you can post bail, you will wait for trial outside prison. After that, you will stand trial. At the start, you must enter a plea, guilty or not guilty. The prosecution and defense will present their cases, and the jury or judge will decide the verdict. Finally, if you are convicted, the judge will decide your sentence. But remember, you can also file an appeal. If you are acquitted, you will be free immediately. Later, you might even be eligible for parole if there is a custodial sentence. The lawyer also reassures her about her rights. You have the right to remain silent during questioning. You are entitled to legal representation. And most importantly, there is a presumption of innocence until the prosecution proves guilt beyond reasonable doubt. By explaining the process step by step, the lawyer turns a frightening situation into something the client can understand. The story shows how vocabulary, grammar, legal phrases, and key expressions all come together in real legal advice. So let's review what we just covered today about the criminal justice process. For vocabulary, we learned the main stages: arrest, charge, bail, trial, jury, verdict, sentencing, appeal, and parole. Grammar, we practice sequencing words first, then, after that, finally. These connectors help explain the criminal process step by step in a way clients can follow. And legal phrases like post bail, stand trial, enter a plea, and file an appeal. These are the practical expressions lawyers need when speaking to clients. And key expressions, we reviewed professional terms like the right to remain silent, legal representation, custodial sentence, probation, double jeopardy, and presumption of innocence. And we also practice a story. We put everything together in a client scenario where a lawyer explained each stage of the process clearly and reassured the client about their rights. Now, you can explain the criminal justice process to clients in clear, professional English, from arrest to verdict and even appeal.